Hello, everyone, and welcome back to yet another session on polity and constitution. I hope I'm audible as well as visible. Great, audible and visible. Let's wait for those to join, and then we'll begin our discussion for the day. Okay, let's begin our discussion now. Others can keep on joining in the meantime. So, in the previous class, that is yesterday, we had taken up for discussion the remaining points on municipalities. So, the second ARC recommendations on how to improve the functioning of municipalities. We also saw the recommendation of the 15th Finance Commission, right? The recommendations therein on what kind of funds can be given, how much funds can be given. Beyond this, we saw the significance, the importance of local self government. Now, after we are done with this, we came to discuss the judiciary. Under judiciary, of course, the very important topic Supreme Court, their appointment, their removal, other terms and conditions of service, all such things. And we were, or we had entered the domain of jurisdiction, the powers of Supreme Court, wherein we are studying about what is called original jurisdiction. The last topic that we covered yesterday was original jurisdiction. Now, coming to the topic at hand today, we'll be covering the remaining jurisdiction of Supreme Court, revisory, SLP, writs, all such things, then high courts, subordinate courts, and then NALSA, and then we look into judicial independence and also very important pendency of cases. So many pending cases. What's the reason, concern, and how to solve the issue of pending cases? Okay, I hope you have been studying your monthly magazine on a regular basis. The studying of Yojana Kurukshetra is happening. The book Political Theory revisions full swing. You wrote the answers for the previous year questions from local self governance, and of course, you must have revised the PPTs also. Okay. Hoping that this has been done, let's begin our discussion for the day. But again, we know we start our day with 5 questions, starting with the very first question. Okay, so for a lot of you, you have marked C as the answer. Consider the following statements regarding the parliamentary privileges. They cannot be arrested during the session of the parliament for both civil and criminal offences. Only civil offences. Only civil, not criminal. Again, you'll have to go back to your chapter Parliament and revise parliamentary privilege. We had specifically mentioned this that they cannot be arrested 40 days before, 40 days after, and during the parliamentary session, but only on civil matters, not in criminal matters. So, of course, one is incorrect. The presiding officer of the House has the final authority in deciding matters of breach of privilege. Absolutely correct. The presiding officer is the boss. So B2 only is the right answer. Excuse me. Moving on to the next question. Please mark the answer. Why have you marked C as the answer? And that to an overwhelming majority of people. The number of offices of chairpersons reserved for scheduled caste and scheduled tribes in the panchayats at each level should be in proportion to the population of the state. And this is correct. No problem. Right? But not less than one third of the total number of seats amongst chairpersons in the municipalities. Amongst chairpersons, state legislature may by law decide. Yes or no? The chairperson's seats reservation in municipalities is not mentioned in the constitution. The respective state legislatures will decide. Again, you'll have to refer to your slides and see as to whether this statement was right or wrong. This is actually an incorrect statement. A1 only is the right answer. Okay. Moving on to the third question. Okay. Thankfully, a lot of you have marked this as correct. A judge can be removed only by an order of the president, of course, but that order is based on a motion passed by majority of the members of the parliament, and that is a special kind of majority. One is correct. When a removal motion is signed by members of the parliament, is submitted to the speaker or chairman, he or she can refuse it. Of course, this is correct. And the committee that investigates into the charges against the judge consists of members of parliament. No, it consists of the inquiry committee. The inquiry committee comprises of judge of Supreme Court, chief justice of High Court, and an eminent jurist. So three is wrong, only two being the right answer. Question number 4. CJI and High Court judge, not Supreme Court judge, Chief Justice of High Court. Some of you have marked B and C, B and D as the answer. It is an elected body. Gram Sabha is an elected body. Amazing. And it is a village assembly of all the people. No, Gram Sabha is the assembly of all the registered voters, adult population whose name is in the electoral roll. That is what is a Gram Sabha. C is the right answer. And last question for the day. In case of ordinary bills, Rajya Sabha is equal powers as that of Lok Sabha, of course, equal powers, while LCs are subordinate to LAs. Yes, there is no concept of joint sitting in the councils. One is correct. In the case of money bills, our Rajya Sabha and legislative councils are subordinate to Lok Sabha and the legislative assemblies. 2 is also correct. C, both 1 and 2 being the right answer. That's it. We are done with 5 questions for the day. Revisions are required. We saw in the first 2 questions, especially, that revisions have been improper. Okay. Now coming to jurisdiction, of course, so let us show the leaderboard also. Funny, Suhas, Tulsi, Aditya, Dinesh, and Yuvashri. Only people who got all 5 correct. Or this large group of people, very few got all 5 correct. Then Kirtana, Uday, Pragya, Ramavat, Mafazzal Hussain, Krishna, Tanya, Suman Srivastav, Pranita, Tulsi, Naveen, Rupal, Sonali, Hari Kirti, Twisha, Sanskar, What is SAT? Sat, Sat, I'm not sure. So getting 4 correct. Okay, Mridul asks, what is LC? Legislative Council. Some kind of body is there. We have studied in the previous classes, right? Anyway, so moving on now to understanding the jurisdiction of the Supreme Court. So we saw yesterday when it comes to the Supreme Court's area of influence, Supreme Court's power, there is something called original jurisdiction. Those areas where the Supreme Court takes up matters directly, right? Those areas where the Supreme Court has the is the sole authority to take up a case. Those are what are known as those areas are the original jurisdiction of the Supreme Court. Then we have appellate jurisdiction. The appellate meaning by way of appeal. What is appeal? When you file a case from the lower court to a high court to Supreme Court, that is what is called appeal. So let's see and understand how the court system functions. At the lowest level, if you have any kind of issue, concern, or problem, you approach the subordinate courts. Then your next challenge would be in the high courts. So the story starts here. This is where the case is filed. You don't like the judgment, you are unhappy with the judgment, you approach the high court. Now, in the high court, cases are normally heard by one judge only. So, we have the concept of what we know as single judge bench. Meaning only one judge. What is bench? Bench means group of judges sitting together. That's a bench. It's like a pride of lions, flock of birds, right? So similarly, group of judges is called a bench. Group of lawyers is called a bar, not the bar you are thinking of. This bar means group of lawyers. Okay. If there is any problem with the judgment, you don't like this judgment. So when the case is filed here, appeal, go here. If you don't like the judgment, no problem. In the same court, you can appeal in front of two judges. Two judges referred to as division bench. Single judge bench, one judge, division bench, two judges. Okay. Now, if you are still unhappy, difficult to please as a person, you will be given the opportunity to move to the apex court, the country the Supreme Court. No problem. We will go to Supreme Court. In the case of Supreme Court, there is no concept of single judge. Every decision or every verdict, every judgment in the Supreme Court is pronounced by a division bench, DB. If a matter is very important, it goes to 3-judge bench called a priority matter bench. Which has 3 judges. Finally, if any matter involves interpreting the constitution, then it is a constitutional bench with minimum 5 judges. So 5 or more judges are required to be a part of a bench which looks into constitutional matters. So one small thing. See, even the high courts, being court of records and all, they can also look into constitutional matters. But in the case of high court, the constitutional matters are looked over by a 3-judge bench. Okay. Now comes the real concern here. So when you go from the high court to the Supreme Court decides which bench will take up this matter. This is what is appeal. You are appealing here and you are appealing here. Very nice, very good. No problem. But not anyone can randomly get up and walk inside the Supreme Court. That's not possible. If you want to appeal in the Supreme Court, some conditions have to be met. What are the conditions? Number 1, Article 134 capital A. So if you want to appeal against a judgment of High Court in the Supreme Court, High Court must give you a certificate to appeal in the Supreme Court. High Court must allow you to appeal in the Supreme Court. So High Court gives certificate of appeal. Clear? So High Court can give this certificate on its own, or you can start crying there, roll on the floor, right? Do all the drama. Maybe the High Court gets impressed, saying very good performance, and we cannot simply give you a certificate, or we have appreciated your acting very well. Please, certificate, go and appeal in Supreme Court. Please leave from here. Possible. But this depends on High Court. There are certain situations where you need nobody's permission. You can directly approach the Supreme Court, right? What kind of cases? Article 132. If a case is a constitutional matter, now tell me, which court is the final interpreter of the constitution of the country? Of course, Supreme Court. So if Supreme Court is a final interpreter, and if there's a constitutional matter, then how can the High Court prevent you? It cannot. You have every right to move the Supreme Court with respect to any constitutional matter. Now, if there is a civil matter of larger public importance, it involves public interest at large, right? A substantial question of law of general importance, then you can approach the Supreme Court. And lastly, under Article 134, if there is a criminal matter you can approach the Supreme Court. Small caveat there, you can approach the Supreme Court, but here the High Court must have reversed the lower court punishment and would have given you a jail of 10 years or more. 10 years or more of imprisonment. If this is the case, then you can appeal in the Supreme Court. These conditions must be met. That is why going to Supreme Court is not everyone's cup of tea. You cannot simply walk inside the Supreme Court and say, Supreme Court, come on, take up my case. No, it's a final court of appeal and all that is okay, but only based on conditions, right? So in all other matters, think of High Court as the final court of appeal. So beyond that, going to Supreme Court may not always be possible. So this is what is the appellate by way of appeal. So you can see here, this is Article 132, cases involving interpretation of Constitution. This is Article 133 of general public importance, and this is Article 134, which is what? High Court has reversed a lower court judgment and given a punishment of not less than 10 years. So this would be in criminal matters. Okay. That is it with respect to jurisdiction of the Supreme Court, which is appellate jurisdiction. Clear? So in all these three cases, no need of certificate, right? These are special matters wherein you have a right to approach the Supreme Court even if High Court is not giving you certificate. No problem. Clear on this? Everyone? Any doubts so far? Okay. Interestingly, this particular matter, the criminal case where punishment should be 10 years or more, it was not there originally. In the Constitution, it was mentioned, it's still mentioned that if you are given a death sentence only. But in 1968, a bill was brought, which was, looking into expanding the Supreme Court's power to take up matters via appeal. And it is through that particular bill that the Supreme Court actually is now able to take up cases where High Court punishes you with 10 years or more of jail, right? That particular bill was called the Supreme Court Enlargement of Criminal Appellate Jurisdiction Act 1970. And just to clarify, uh, that bill was a last ever private member bill to be passed in the country. Okay, that's it. See, civil matters can be any important matter, let's say a matter of Ram Janmabhoomi kind of matter, any kind of civil matter which involves a larger public interest and all, that will be decided by Supreme Court eventually. Okay, that's it. Done. Appellate jurisdiction. But some of you may say, but sir, we have always seen that the rich and elite people somehow always end up in Supreme Court. How is that happening? How are all these rich elite people entering Supreme Court? If this is the case, even when they're getting a punishment of 2 years, 3 years, 4 years, they file a case in Supreme Court only because of a provision called Special Leave Petition, SLP. Okay, Special Leave Petition. Now, this is mentioned under Article 136. Very important article. This is the article which provides for what? Which provides for the Supreme Court to grant special leave. What is leave? Special leave means permission. Leave here means permission. While we're discussing the chapter Parliament, the bill, the minister or the person who introduces the bill takes the permission of the House. So takes leave of the House. Leave does not mean leave the House only, right? Takes permission. So Supreme Court may grant special leave to appeal from any judgment, order, etc. in any cause, any matter passed or made by any court, any tribunal in the country. So any court, tribunal gives any judgment, Supreme Court can take up a case, can give special permission to appeal before itself. Clear? This is a special situation wherein you will have to request to Supreme Court that Supreme Court, please Supreme Court, take up my case. High Court is not giving me certificate. You take up my case, and the Supreme Court will take up your case if it wants to, right? So here, Supreme Court may or may not take up the matter. Don't feel it is some compulsion on the Supreme Court that it has to take up the matter. Okay? It is not mandatory. This is what is special leave petition. Special permission to petition before the Supreme Court. If the High Court has not given you certificate and your case is not really a very important one, it does not involve interpreting the Constitution, the punishment is 5-6 years of jail only, but still you somehow feel that your judgment of the High Court is not correct, you can request the Supreme Court that, sir, milords, you please look into my case. The Supreme Court may look into your case. Now, let me just clarify. Uh, most SLPs filed are rejected by the Supreme Court. In fact, 90% SLPs are rejected. Before somebody asks, SLP stands for Special Leave Petition, right? This is with respect to the special leave petition. Then one more thing. Ideally, what can be a reason? I mean, the High Court has given a judgment. High Court judges are almost as good as Supreme Court judges. So, when it comes to High Courts, judgment was given. Matter is not very important because if your matter is a constitutional matter, then you can directly go to Supreme Court. Or if the punishment is more than 10 years, you can directly go to Supreme Court. But the point is, it's an unimportant matter, not a very important matter. Punishment is not very huge, not too harsh. Then why is the Supreme Court accepting this? Because it is also adversely impacting the judicial finality. The case drags on and on. So, what are the reasons? Reasons. Reason number one, in the eyes of Supreme Court, if grave injustice has occurred, right? So if the Supreme Court feels that there has been grave injustice, miscarriage of justice has happened, then Supreme Court can allow for such petitions. Or new evidences or fact has come to light, or violation of principles of natural justice has taken place. Principles of natural justice are being violated. What is principle of natural justice? Principles of natural justice. PONJ. Principles of natural justice are not mentioned in some article in the Indian Constitution or some law. These are the principles used world over to ensure fairness in the application of laws. When you have laws in the country, the laws should also be applied in the fair manner. Okay, so fairness with respect to application of laws is what is principle of natural justice. It has three main principles. Number one is nema causa in judex sua. Ignore that. It simply means no one shall be a judge in their own case. Nobody can be a judge in their own case. That's not possible. For example, now think of this. If you are a judge, two people have come to you and are fighting a case. One person is a best friend of yours from college. Do you think the other person, the other party, will have any faith in your judgment? Justice should be done. It should be seen to have been done. That is more important. That is why there is a concept that we follow. That concept is called recusal. If a judge knows any of the parties involved, right, has any prior association, he recuses himself, meaning he tells the CGI, sir, don't give me this case. I will not be able to handle this case because it will be unfair. So, prior association with any litigant, judge takes back his or her name from bench. Why? Because we have to ensure that the delivery of justice is fair. So, this is called recusal. Now, recusal depends on the judge. It is your duty, your responsibility, your moral, ethical obligation to tell people to ensure that what? To ensure that you, if you have any prior association with any party or litigant, you can simply take back your name. It depends on you. No one shall be a judge in their own case. Second, audi alterum partem. Audi alterum partem, meaning right to fair hearing. Hear both the sides, right? So, for all those people who are older siblings in your house, whenever you and your younger sibling are fighting, especially when you were small kids, your mom would come to you and start slapping you and beating you only, right? Or if things go wrong in the house, you are directly beaten in the house without any explanation being sought from you. That is wrong. You have to be given an opportunity to explain your side of events. Next time your parents beat you, you please tell them my principles of natural justice are getting violated. You have to hear me out. You have to hear what went wrong. So, in the case of courts, the judge has to give both the parties an opportunity to speak about or talk about their side of events. Lastly, whenever you are giving judgments, give reasons for judgment. So every judgment would have to be given with reasons, giving reasons for the judgment. Okay, so this is with respect to principles of natural justice. The last principle, giving reasons for judgment, again. So next time, if you ever approach somebody to express your emotions towards them, that you like them, you love them, etc., and the person says get lost, you please ask them, give reasons, right? So reasons must be given for the rejection of your proposal. You can simply tell them, please don't violate the principle of natural justice. Though it may not work there, but at least you can come off as somebody who has a lot of knowledge in polity. That may impress the person to change their stand. Anyway, so this is called principles of natural justice. Uh, if you are able to convince the Supreme Court that in the lower court these things have been violated, then the Supreme Court may accept your petition. May accept your petition. This is called special leave petition. Now, some of you who are reading the news uh, would also know about that. Sometimes in such certain cases, Supreme Court, High Courts, the person demands, I want a change of judge, and the judge says, come on, stay here only. Now, in that case, it's the judge whose subjective opinion matters. Now, what happens is there are some people in life also who are prone to giving a more lenient punishment. Some people are prone to giving a harsh punishment. In your school days, some teachers very easily would allow you to waste your time and just chat and have fun in these classes, substitute classes. Other teachers, the dangerous ones, would come in the substitute class also and start teaching you. Remember? So we all wanted those teachers only, right? That who would give us free time, enjoyment. So the same thing. If I know that there is a judge who is known to be very lenient, right? Then I would prefer having my case in front of that judge. Or if I know that this judge is very strict, very harsh, then I would want my case to be not heard by that judge, right? So these kind of things happen in the court, where the litigant also tries to act over smart, saying that because he knows very well that in the previous similar cases, let's say there's a judge whose stand against corruption is very strict. That judge is known to give maximum punishment in corruption cases. So if I'm a corrupt official, I'll try to convince the judge that, sir, no, not you, sir, you are biased. That judge should decide. Give to some other judge. Now, these are some of the concerns that may be there. it is all subjective to the judge. If you are able to convince the judge that, sir, you are biased, and the judge has belief in your presentation of the events, then maybe he can recuse himself. You can't force the judge, come on, leave the case. Clear? So all these things are there. Anyway, this is sufficient for UPSC. Nothing more than this will be asked in the examination. Don't worry. Enough information. So this is special leave petition. Okay. Now, let's come back here. So the case has been decided. You have appealed in the Supreme Court based on the conditions, or an alternative is also there. What alternative? The alternative is special leave petition, which is not binding. I have mentioned the line here. Supreme Court may or may not take up a matter. Okay. Same goes for recusal. All these things are subjective to judges, right? So they are subjective to judges. If a judge wants to recuse, they will recuse. If a judge does not want to recuse, they will not recuse. A very simple example is that uh, a few years back, one former Chief Justice of India, there was an allegation against the judge, the CJI, of sexual harassment. And that was Justice Gogoi. And the Supreme Court formed an in-house committee. Within the Supreme Court, 3 judges were chosen to form a committee to look into the allegation. And those 3 judges comprise of Justice Gogoi himself. That is a classic case of violation of principles of natural justice. So in that case, because of lot of hue and cry being raised, later on Justice Gogoi took back his name, saying that, okay, you guys decide. So this is a classic case of violation of the principles of natural justice. Okay. But the larger point is, what if after the Supreme Court's judgment has come, you are still unhappy? You are still unhappy. Then what you can do is you can appeal in the Supreme Court again. This is called review petition. So in your school days, when the marks came out, the answer sheet was shown to you. Some of the enthusiastic people would go to teacher saying, Miss, ma'am, 2 more marks, please. 4 more marks, please. Here, this question, I need more marks. As if it's your birthright to get more marks. So here also, if you don't get a judgment in your favor, you may ask for a review petition, meaning petition, request. You request the Supreme Court within 30 days from the date of delivery of the judgment. You can request the Supreme Court that, Supreme Court, I am not happy with the judgment. What nonsense. You please recheck your judgment. This is what is called revisory jurisdiction. Okay. This is Article 137. Revisory jurisdiction. Article 137. Supreme Court shall have the power to review any judgment pronounced or order made by it. Okay. So again, this is based on discretion. Okay. Within 30 days. Preferably same bench must take up the case. Okay. You cannot say, sir, you 5 people, sorry, some other 5 people should decide. No, no, no. But what if a judge of the bench has passed away? You can't call him back. Come on, how are you dying? You can't die. One case is pending. Come on. That will not happen, of course. So, as far as possible, we'll have the same judges who decided the case originally to be a part of the review petition. Okay. And it is optional. Supreme Court may or may not allow such petitions. Okay. This is there. So, constitutionally, this is where the journey of your case is over. Meaning what? Meaning that once you apply for review petition, then the Supreme Court gives the same judgment, that game is over for you. Nothing happens now. After rechecking also, you are still getting 24 marks out of 100. Then get ready to get thrashings from your parents. Prepare yourself mentally. You have tried every means possible. Same thing in Supreme Court. And constitutionally, nothing else can be done. But Supreme Court in 2002 said, let's see, the task of judiciary is to ensure justice by any means possible. In fact, Supreme Court has said that judiciary can go to any extent to meet the ends of justice. To deliver justice, we can go to any extreme. So, Supreme Court in 2002 came up with a very unique concept. Supreme Court said that I will give you one more chance. Come on, try once again. Now, constitutionally, nothing can happen, but you can try once more. This is a judicial innovation called curative petition. So, here you can be given an opportunity again by Supreme Court that, okay, you want a chance to present your case once again? Come on, try once more. This is a judicial innovation in the Ashok versus Rupa Hurra case of 2002, 5-judge bench. Okay, and this curative petition is not mentioned in the constitution. Clear? And this is applicable after failure of review petition. This is what is called curative petition. Supreme Court says the act of court shall prejudice no one. Court is under the obligation to undo wrongs done to any party, even if the wrong has been done by an act of court itself. So this is with respect to the revisory jurisdiction of the Supreme Court. Once you are unhappy with the curative petition judgment, then what do? See, understand that if you are unhappy with the revisory jurisdiction of the Supreme Court, curative petition and all, and you are still not happy with the judgment, then the only option for you is sit at home and cry. Okay, that's it. Nothing else can be done. Are we clear on this? You may say, sir, but if I am at the receiving end of punishment, I can go for clemency also. But that is only when you are getting some punishment, right? Then only that clemency applies. But if you want somebody else to get the punishment and he is not getting the punishment, then you can't go to president, right? So this is a end of story for the case. And even when you go to the president for clemency, that is not a judicial matter. It is a matter of mercy. You are not challenging Supreme Court judgment. Clear? So review petition is a part of the constitutional process. Article 137. Curative petition is not mentioned in the constitution. It is a judicial innovation. It is based on judicial discretion. Okay, the court decides. If it feels so, it will do it. This is with respect to the appeals in the court. Clear? That's it. Solve this question. Came in the year 2021. Okay. So let's look at the question and I'll tell you something very interesting. Uh, with reference to Indian judiciary, any retired judge of Supreme Court of India can be called back to sit by the Chief Justice with prior permission, of course. Article 128. This is correct. Retired judges can be called back. No problem. A High Court in India has a power to review its own judgment as the Supreme Court does. Now, for the Supreme Court, there is an Article 137, review petition, revisory jurisdiction. There is no separate article for the High Court, but it is not mentioned as per the Constitution. If you remember, we had seen yesterday the topic Court of Records. Court of Records have two advantages, two special powers. Power number one is to punish for contempt. Power number two is to review their own decisions. Shivdev Singh case 1963, Supreme Court has said that high courts are court of records and hence they also have the power to review their own decisions. They can. It happens on a regular basis. Yes or no? So actually 2 is correct. Statement 2 is correct. And the correct answer is actually C. But then I marked only A, one only as the correct answer. Why? Because UPSC answer key said that second statement is wrong. According to them, A was the right answer. Now, who would go and question UPSC? And the beauty of this is that the answer key is released only after the entire exam process is over. So nobody can raise any question there. What will you do? You'll go and say, sir, because of that one question where the answer was wrong, I could not clear prelims, and then I could not clear mains. I could not fulfill the dream of my family to become an IAS officer. This won't work like this. Sadly, you have to live with it. That is why the best situation is that don't hover near the cutoff, score comfortable marks, 100, marks, so that one or two such situations do not cause any harm or damage to you. Okay, are we clear? So we are not really sure why UPSC thought second statement is wrong. If they had mentioned this as per Indian Constitution, then we could have considered it okay. They are looking at an exact provision of the Constitution, right? So in that case, it could have been wrong. But my advice is, in future also, always understand that this statement is actually correct. It is not wrong. And in future, in this very same polity class, we will I will show you how UPSC standards are completely confusing. So when we study fundamental rights, I'll discuss this question again, because Supreme Court or UPSC has made a mess of this topic by asking a question from the same court of records, but this time they have taken that concept as correct. So UPSC is UPSC. Okay. See, Article 215 is a constitutional provision, but it only says that High Court is court of records, meaning High Court's judgments have evidentiary value. It is an interpretation that all the court of records will have the power to review their decisions, which has come from Supreme Court judgment, which is not mentioned in the Constitution. Clear or not? This is the difference. Okay. So no need to feel sad. It's okay. Stuff happens in life. Don't worry. One or two questions here and there can be wrong. Even UPSC can make mistakes. So no problem. Now, advisory jurisdiction. I'm sure you have seen this movie, right? Various names across the country. So this is Three Idiots. I think the Tamil version is called Nanban, if I'm not wrong, starring Vijay and all. So this is a movie which disturbed peace in the lives of lot of people, because it opened doors for following the passion, right? Dangerous for parents. So suddenly people started seeing this movie and said, I can follow my passion. In this movie, Madhavan has lot of talent also. Passion requires talent as well. I mean, of course, nowadays it's not talent, but so free advice is something that only Amir Khan can give. Supreme Court cannot give. Okay, Supreme Court can give advice under Article 143, but only when asked. When the president seeks opinion from the court. So this advisory jurisdiction is what? President can seek opinion. Opinion from Supreme Court on what kind of opinion? Number one, legal opinion on general matters. Legal opinion on general matters, and also can seek opinion on interpretation of laws. Now, Supreme Court is the final interpreter of all the laws in the country. So, if the president seeks opinion of Supreme Court, tell us what is this meaning of consultation, etc. And Supreme Court can interpret, and Supreme Court has to give the advice. Here, in this case and this case. So, in this case, Supreme Court must give the opinion or advice. Here, Supreme Court may refuse also to give opinion. Supreme Court can say, sorry, I have no time and all for this nonsense. So sometimes what happens is that the government, before filing a case in court, wants to get the opinion of Supreme Court judges only. Tell us, should we file a case like this? Because whenever the government files a case in court, they have to hire the attorney general, solicitor general, and all. They have to pay the salary, etc., money to them, which is a money coming out from CFI, taxpayers' money. So people's money is wasted, right? So the government, before filing a case, sometimes also wants to know Supreme Court's opinion. That is what is legal opinion on general matters. It happens a lot, right? 10, 15 times since in 15 times rather since independence it has happened. Now this, you can see that this is referred to as presidential reference, RE. So whenever you find this word before any case, it is not actually a case in the true sense. It is actually the government seeking the opinion of Supreme Court. And this must be given by a minimum 5-judge bench, not less than that. Uh, as for example, recently it happened in the 2G case, where the government wanted to file a case with respect to 2G, and the government wanted to know Supreme Court's opinion on the case they are about to file, that are all the documents proper, is the matter clear or not, do we have a chance to win the case if we file a case or not, such kind of things. Okay, now you can go back to your collegium judgments and find out that the third judge's case is not actually a case. It is presidential reference under Article 143. So, a classic example here is the third judge's case. An example here would be 2G case. Clear on this, everyone? Advisory jurisdiction. Okay, so in this case, Supreme Court has to give advice, it cannot refuse. But here, Supreme Court can say, I will not give my opinion. You file a case if you want to, then we'll decide. You can't ask for my opinion. Clear? That's a difference. Article 143. Solve this question. Came in the year 2010. Okay, so Supreme Court of India tenders advice to President of India on matter of law or fact on its own initiative. As I said, when nobody is asking you, please keep quiet. Don't become Damir Khan. Only if matters relate to fundamental rights, of course not. It can be any matter. If he seeks such an advice, 2 is correct. B, only 2 is the right answer. Okay. Now, writ jurisdiction. Writ. What is the meaning of writ? Writ means order. Writ means directive. Order or directive. Article 32. Writ meaning the court issues orders. Writs can be issued. So Supreme Court can issue writs. Can issue writs for protecting fundamental rights. For protecting fundamental rights. And very important, high courts can also issue writs for protecting fundamental rights, plus on other matters also. This is under Article 226. That is why writ jurisdiction is not an original jurisdiction, because original means direct, also exclusive. Writ jurisdiction is direct but not exclusive, meaning in order to protect your fundamental rights, you can directly go to Supreme Court. But can you go only to Supreme Court? No, you can go to High Court also. So writ jurisdiction, direct but not exclusive. It is shared with the high courts. Are you clear? Writ jurisdiction. There are 5 different types of writs: habeas corpus, mandamus, prohibition, certiorari, and quo warranto. We'll discuss all these writs when we study fundamental rights, under which we'll be studying Article 32. Now, some other important provisions. For example, Article 138. If the government of India or the government of state and the government of state are in agreement that more power needs to be given to the Supreme Court, then the Supreme Court's jurisdiction can be enlarged by the Parliament, by law. So please tell me one thing. In case you want to decrease the power of the Supreme Court and High Courts, what is the majority required? Please tell me. It requires a special majority and also ratification by at least half of the states. Are we clear? because modifications under Supreme Court and High Court provisions is a part of federal structure. So, in case you want to modify, which could also include decreasing the power of Supreme Court, limiting its power, that would require a special majority, also the approval of half of the states with a simple majority. Again, we'll have to go back and revise the types of majorities in the what? Indian legislature. Okay. Then, 139 capital A. Supreme Court can transfer cases from one high court to another. We have seen this happening a lot, that Supreme Court transfers cases from one high court to another, or sometimes transferring a case to itself, right? Back in the late 2000s, case was transferred from the Gujarat High Court to the Jodhpur High Court, a case involving Amit Shah, because the issue was that in Gujarat there was a possibility of the judgment not being fair, or this Bilkis Banu case was transferred from Gujarat to Bombay High Court. So transfer of cases happens and Supreme Court can do it, right? When number one, suo moto. What is suo moto or suo motu? MOTU, MOTO. Same thing. Suo moto means on its own. On its own motion. That means on its own, by itself, can do it. Second, if Attorney General requests, or if the petitioner or litigant, the party, the litigant requests. Clear? Why would the petitioner request? A classic example is uh, the situation of Nupur Sharma. So Nupur Sharma against her across the country, defamation cases and cases with respect to Section 505, hurting religious sentiments, creating animosity in the country. All these cases were filed, and multiple cases filed across the country. So she approached the Supreme Court, asking Supreme Court to transfer all the cases to Delhi. It would be easy for her to take up all the cases in Delhi because she is from Delhi, right? And Supreme Court did oblige in that case. It was logical, though without, not without making some very irrational statements. We'll discuss that later on. So this is Article 139 capital A, added in 1976 by the 42nd Amendment Act. Lastly, Article 141. The law declared by Supreme Court shall be binding on all courts within the territory of India. So any law that is declared by the Supreme Court is binding on all courts, but the Supreme Court is not bound by its own judgment. Other courts are bound by Supreme Court's order. Okay. Now comes a very, very important provision. This is Article 142, the absolute power of Supreme Court. This is the power which is the source of judicial activism. So how does Supreme Court get this power to transfer cases from here and there? 139A. How does Supreme Court get the power to take up matters from some other cases, other courts' judgments? 136. Fair enough, judicial powers. But we see Supreme Court giving orders to government, giving orders to random bodies, statutory bodies, giving orders to parliament, etc., um, making rules, regulations in the country. All such things. How? How is the Supreme Court able to interfere in every other organ's area of working? Because of Article 142. Let's read. The Supreme Court, in the exercise of its jurisdiction, may pass such decree. Decree means conclusion, right? May pass such decree or make such order as is necessary for doing complete justice. Supreme Court can pass any kind of order, any kind of conclusion in any cause or matter pending before it if it wants to ensure complete justice. So, in the garb of complete justice, a Supreme Court can give any kind of judgment, and any conclusion so passed or order so made shall be enforceable throughout the territory of India. This is what is the absolute power of Supreme Court. This is what is judicial activism. There is no definition of what is complete justice. It's an English word, right? When you ask me the meaning of an English word, it pains, right? So some logic is also required before we proceed to make statements like this. What is complete justice? How would I know what is complete justice? That is subjective to one judge. If I go to court and say right now, I have a problem with the government's decision, this policy is not right, the court can give a judgment saying policy cancelled because this person feels bad. I am doing complete justice. That's also complete justice, right? Whatever steps Supreme Court has taken to improve the lives of people in general, right? Complete justice. Supreme Court interferes in the parliamentary functioning also, states functioning also. Supreme Court decides on matters of defection nowadays, right? Remember, Supreme Court told in the Kesha Meghchandra Singh case that sorry, speakers decide ideally in 3 months. How can the Supreme Court decide make all these judgments? Because of what? Complete justice. Supreme Court will say we are doing complete justice. Okay, this is Article 142. That's it. We'll study judicial activism later on. Don't worry. Lastly, Article 145, rules of Supreme Court. Look at the beauty in our country that see, just to add one point, like a lot of you are asking, sir, not a lot, one or two people are asking that, sir, what is the check? Can we amend this article? Yes, we can, but we have seen Supreme Court again and again trying to hold on to this power very strongly. In the recently concluded Shilpa Salesh case of 2023, Supreme Court, one justice call, he made a statement that Supreme Court has a jurisdiction to depart from procedure. Please hear me out. I am quoting verbatim as far as I can recollect the statement made by him. That Supreme Court has the jurisdiction to depart from procedure and statutory provisions of law if such a departure was required to establish complete justice. So, just because I feel that justice will be done fully, comprehensively, I can depart from procedure, I can depart from statutory provisions, etc. So, this kind of power is the most amazing power that is there. right? With respect to Supreme Court, that I remember this scene from this series called Sacred Games, where the Supreme Court says the protagonist Nawazuddin Siddiqui says that sometimes he feels he is God, right? कभी कभी लगता है अपुनिच भगवान है. That's what is Supreme Court saying here with Article 142. Anyway, we'll look into this in detail under activism separately. And look at this. So I had that meme in the slide, but I did not use it here because of lot of non-Hindi audience. So I could not find a corresponding meme in other languages, so I had to exclude that. With the approval of the president, Supreme Court can make rules for regulating generally the practice and procedure of the court. So who makes the rules and regulations? Tell me. To function within the court, hiring of staff, the court fees, which case goes to whom, who decides that? Supreme Court decides that. Completely independent with respect to internal functioning, with the approval of president. This is just a ceremonial kind of approval, right? A formal approval. Supreme Court makes its own rules on how to run the Supreme Court. Okay, and minimum number of judges to decide on matters of interpretation of the constitution, which is what? Constitutional bench. So we have seen this earlier only, that constitutional bench will comprise of how many judges? Minimum 5 judges, 5 or more judges. And not just this, beyond this, one very important point, every decision in the Supreme Court is taken by a majority. So if it's a 3-judge bench, 2:1, right? CGI has no special power. If there is a 3-judge bench and CGI is a part of the judgment, if other 2 judges give a different judgment, that is a final judgment. Judgments or decisions are given by majority vote. Clear? Now, there is also a possibility in case of a division bench. What is division bench? 2 judges. There can be 1:1 also, which is known as split verdict. Split verdict. Such matters are then referred to a 3-judge bench. Okay. So this is with respect to the Supreme Court. We are done with all the provisions in the Constitution as far as the Supreme Court is concerned. Now moving on to the great high courts in the country. We have 25 high courts across the country. How many high courts? 25 high courts. Now, across the high courts, you will find that there are 2 types of judges: permanent and additional judges. In total, we have 1114 judges in the high court across the country, and number of judges varies from one high court to another. is different in each high court. Okay, that's there. See, just to give you an example, let's give an example. The Allahabad High Court, 160 judges, 160. Bombay High Court, 94 judges. Sikkim High Court, 3 judges, 3. Rajasthan High Court, Delhi High Court, very popular. Delhi High Court, 60 judges. Rajasthan High Court has 50 judges. Tripura, Manipur High Court, 5 judges. Number varies from one high court to another. The total is 1114. And just to point out, you'll be surprised, the current vacancy in the high courts is 333. 333 seats in the high court. High courts across the country are vacant. That would mean 1114, 29, 18, roughly around 30%, right? This figure roughly around 30% vacancy in the high courts. Of course, we'll have pending cases in the high courts, right? And then the collegium of 3 judges wants to appoint also. Okay. Now, there shall be a high court for each state, clear? But please understand, the high court may not be in your state. It is possible that high court may not be in your state. We have the concept of shared high courts also. So common high court for 2 or more states is possible, just like common high court for a common governor for 2 or more states is also possible. Clear? So this is with respect to the establishment and creation of high courts. Just to showcase this, please tell me, looking at this table, how many high courts serve more than one state? Tell me quickly. How many high courts serve more than one state? So far, all wrong answers. Okay, somebody has written, Jyoti has mentioned the right answer. Soumya, Nisarg, Prateek, Priyanka, Krishna. Now people are writing some right answers. You don't hear the question properly, no understanding, half asleep, right? The question was, how many high courts serve more than one state? You immediately jumped on and started counting 1, 2, 3, 4, 5, 6, 7. Will I ask that question? Huh? Now you think that this is a question we should be asked to you. Anyway, one such high court is a Bombay High Court. Bombay High Court serves 2 states, Goa and Maharashtra. Second High Court is the Guwahati High Court, which serves 4 states, Arunachal, Assam, Mizoram, Nagaland. And the Punjab and Haryana High Court serves 2 states of Punjab and Haryana. All other high courts are serving state and UT or only UTs. There is only one high court which serves two UTs, and that is a Jammu and Kashmir and Ladakh High Court. There's a very unique High Court called Delhi High Court, which serves only one UT. Otherwise, all High Courts serve a state, sometimes serving a state and a UT, and sometimes serving what? Serving more than one state also. Clear? Okay. And please don't forget, Lakshadweep jurisdiction is in the Kerala High Court, and Andaman Nicobar is for the Calcutta High Court. Don't think Andaman Nicobar is Madras High Court. Okay? Please. So this is with respect to the high courts and their jurisdiction in the country. Now, in some cases, you may find we are referring to Allahabad High Court, Jodhpur High Court, though it is the Rajasthan High Court only, but the High Court is in Jodhpur. So this has been there originally. So in that same state, say UP, there are multiple benches of High Court, meaning some judges sit in Allahabad. In fact, most of them. Some other judges sit in Lucknow. In a larger state, we have multiple benches of High Courts. Okay, this is what we were discussing in the previous class yesterday also on Supreme Court, that we only have one Supreme Court. We should have multiple benches of Supreme Court. Bench means what? Group of judges. Similarly, in the states, we have multiple benches of High Courts. And some High Courts, like say, uh, High Court of Rajasthan, High Court of Madhya Pradesh, etc. But some other High Courts name is which have been set up originally are Allahabad High Court, Bombay High Court, Madras High Court, Guwahati High Court. These High Courts are not called High Court of Tamil Nadu or High Court of Maharashtra. Their name is Bombay High Court only. So if I say Bombay High Court or Madras High Court, don't be angry, sir. This is the old name. Please say the new name. It is the name of the High Court. Okay. Now coming to the question. Please solve this question asked in the year 2006. Very simple question. Mark the answer, please. Oh, poll. Okay, a lot of you got this correct. D. In India, every state has a high court in its territory. Now, this may not be correct. Within its territory, sorry, right? This is not correct. So, A is wrong. So, both A and R are true. A is wrong, A is wrong, A is wrong. Right answer. The Constitution provides for a high court in each state. Now, again, you may say, sir, this word in is wrong. It should be for each state, a better word. Of course, but that's UPSC. What can we say? Whatever they tell us, we'll have to follow. Now, coming to appointment, I think we know the appointment. But nevertheless, I would want you to tell me, how are the High Court judges appointed? What is a collegium? And what does the collegium comprise of? The appointment is under Article 217. In the meanwhile, I'll be writing about the number of judges to increase the number of judges. What is required? Collegium, one CJI, or we have one CJI only. CJI plus two senior most Supreme Court judges. Okay, very good. Now please answer this question. To increase number of judges in the high courts, parliament by law, yes or no? How nice. Some of you are writing yes. Simple majority. By law. Yesterday only we saw it. That for increasing Supreme Court judges by law, but to increase number of judges in the High Court, President, executive order. Are we clear? President by law. Oh, unique word. Creating own statements. What is president by law? Presidents issue order. Please don't create own phrases. By law means something specific by a simple majority. How can the president pass something with a simple majority, one person only? Right? Okay. See, again, the original word was every judge of High Court shall be appointed by the president by a warrant under hand and seal. Oh, Anjali, you are written in the note. I have written this president by law. Amazing. Please take a screenshot of it and send it on my mail. I'll see where I have made the mistake. President by law. Amazing. Great. I'm sure the schooling system right now has gone down the drain completely. Right? Lack of any kind of respect and authority for the teacher. Is this what is there everywhere, or is it for some people only? I'm not really sure. It's pretty surprising. I'm surprised every day. Anyway, the future awaits. Life is difficult. You'll realize very shortly. So, coming back here, rather than wasting time, the point here is the same old logic. The judges are appointed by the president by warrant under hand and seal. Uh, After consultation, again the same logic, consultation with the Chief Justice of India, Governor, and in the case of appointing a judge other than Chief Justice of High Court. So all of them should have been consulted. And let me just tell you something. Uh, this was the case in the first judge's case. In the first judge's case, this was the point being discussed, that consultation mandatory or not. And we know what is the reality. Reality is the collegium system. There one more small question, please, for everyone to answer. Transferring judges. Tell me, transferring judges from one high court to another. What is the collegium? No collegium. What is this? 5 judges, 1 plus 4, but we also need to consult the chief justices, right? The chief justice of the High Court, incoming and outgoing. So those two people also have to be consulted. And I think we have established yesterday only that it is just consultation. But yes, we should consult those judges also of the High Court, the bosses there, before we transfer any judge from one High Court to another. One more small point of difference. The Supreme Court judges, the retirement age is 65. The High Court judges, the retirement age is 62, not 65. Difference. Supreme Court 65, High Court 62. Clear? And one more thing. Uh, just a couple of slides back, I mentioned this point called additional judge. So, what is this additional judge? See, additional judges are judges only of the high courts, but what we do is that the courts will appoint some person as a temporary judge for 2 years. Largely in those 2 years, the chief justice will look into the behavior of the additional judge. How is he giving judgments, or what's the knowledge level, all these things. And after 2 years, the name of the judge can be recommended for being made permanent if he belongs to a family, sorry, if he has talent or skill, right? So this is called additional judge, like a temporary judge for 2 years. Clear? So this is with respect to additional judges of the High Court. Done with the appointment. Now, coming to qualification. Here again, please don't say, sir, citizenship is also, that is again a qualification. You have to be a citizen of the country. Here also, there is no tenure, no time period. You simply can become a judge at any point of time, but the point is you retire at the age of 62. What's the qualification? Number one, you have to be a judicial officer for at least 10 years. At least 10 years. What is a judicial officer? Judicial officer. Judicial officer means a judge in the lower court. Simple. That's it. Okay. Or you can also be an advocate in high court, again for at least how many years? At least 10 years. Here there is no concept of eminent jurist or a distinguished jurist that we had in the case of Supreme Court. And just to remind you, the same qualification is there to become what? Tell me. This qualification is also a qualification which is required for appointment of people under Article 165. Same for Advocate General. Okay. For Supreme Court judges, it's the same for Attorney General. For High Court judges, same for Advocate General. And that's it. We are largely done with most of these points. Now, couple of things quickly. Number one, removal. Removal, tell me. Removal is same as Supreme Court judge. We have seen the process. Here also, salary is charge expenditure on CFS, Consolidated Fund of the State. One small point, salary is charged on CFS, but pension from CFI. Okay. For Supreme Court judges, both their salaries and pensions come from CFI only. But for High Court judges, till you are a High Court judge, the states pay the salary. But when you retire, because you have served under multiple high courts, so the center pays a salary, pension. One more thing. Yesterday we saw that the Supreme Court judges, once they retire, they are not allowed any kind of future employment or as a lawyer, meaning they cannot practice law in future in the country. Can High Court judges practice law? Yes and no. They cannot practice in those courts where they have been a High Court judge. Can't plead or act in courts where they have acted as a judge. Okay, meaning what? For example, if there is some kind of some judge, Justice ABC, this judge was a judge originally in Sikkim High Court, and then he was transferred to Bombay High Court. Finally, he was made the Chief Justice of Patna High Court and he retired. Now, my question is, can he become a judge of Delhi High Court? Can he practice law in Delhi High Court? Yes, he can. Can he practice law in Supreme Court? Yes, he can. Can he practice law in Bombay High Court? Tell me. Of course not. Can he practice law in Patna High Court? Cannot. Can he practice law in Guwahati High Court? Tell me. Guwahati High Court. Yes, he can. So the High Court judges on retirement can practice law in all the High Courts and the Supreme Court, but only in those High Courts where they have not been a judge. Okay, that's it. Practicing law means pleading or acting as a lawyer. That is called practicing law. How else will you practice law? So, pleading or acting, meaning lawyer, advocate. Clear? Okay, that's it. And then we know the same story for salaries and allowances, which schedule, oath affirmation, which schedule, salary, which schedule. Come on, quickly, don't waste time. Somebody will mention some wrong answer. Definitely. Salary is mentioned under Schedule 2, Oath and Affirmation Schedule 3. Salary 2, Oath 3. Okay? Now comes jurisdiction. See, when it comes to the high courts, as far as their jurisdiction is concerned, these two are original jurisdiction, meaning election disputes involving elections of MP, MLA, MLC. These electoral disputes are taken care of by high courts directly. Okay. Second, admiralty involving law of seas, let us say peninsular India. If something goes wrong here, then the corresponding high court there is the one where the case is taken up for the discussion. So if you want your matter to be discussed in high court directly, not in the lower court, commit a crime in the high seas of our country, and then your case will be discussed in the high court directly. In fact, appellate jurisdiction, this is the real purpose of high courts. High courts are actually the court of appeal. Clear? And for all matters which are there in the lower courts, you need no certificate, no approval, no permission to approach the high courts. High courts were meant to be the actual court of appeal, where every case, every matter will be appealed in the high court. But the limitation is from high court to Supreme Court. That's where the limitation comes. And lastly, the writ jurisdiction, we saw Article 226, where orders can be issued for protection of fundamental rights, also other matters. What kind of writs? We'll discuss it later on. Solve this question. Came in the year 2007. Okay, so the mode of removal of judge of High Court in India is same as the removal of judge of Supreme Court. One is correct. After retirement from the office, a permanent judge of High Court cannot plead or act in any court or before any authority in India. This is wrong. After retirement as a High Court judge, you can act in Supreme Court. You can act in all those high courts where you have not been a judge. Simple. So two is wrong, one is right. Somebody had mentioned by mistake I have done B, it will be D from my side. So from my side, your answer was wrong, though by chance you got it correct. Lucky mistake. Removal, same as Supreme Court judge. Yesterday also we had discussed this. Clear? Okay. Let's do one thing. Let's take a break. I'm sure you are waiting for that break to enjoy life. We'll come back at 8:15 and we'll continue our discussion further. We'll continue our discussion further from 8:15. Okay. Break, please, guys. Let's continue. Surya, in case of charges of terrorism, will the accused be tried in Supreme Court, respective High Courts of state? Terrorism charges start at the ground level only, right? So they will be tried in the lower courts, then High Court, then Supreme Court. It's a criminal case. Anjali, yes, yes, okay, Anjali, no problem. Uh, uh, Point two of original. See, this admiralty involving law of seas. So, if anything wrong happens with respect to the territorial waters of India, let's say this is the territorial, this is the peninsular India, and this is where some crime has taken place. Now, in this situation, what happens? Where do you go file a case? You go and file a case in a district court? No, you go and file a case in the corresponding High Court, Admiralty. Okay, that's there. Soumya, judges and the government will interact and discuss. The government can have a lawyer from their side, the attorney general, to explain things, but it is just an opinion of the Supreme Court. You don't really need a lawyer because there is no case to argue there. Nirbhay, there is no appointment with respect to, there is no role of the governor in the appointment. The only role is that the governor is consulted. So when the names are finalized, the copy is sent to the governor, and the governor will look into these names and can give his suggestions, if any. Nobody cares about his suggestions. Okay. Yes, Gauri, it can be appealed. Kalbi, we'll discuss subordinate courts now. Anuradha, laws mean interpretation of laws. Yes, Abhishek, they can plead in the High Supreme Court. They cannot plead in that High Court. Okay. Sandeep, yes. For every government official, there is a mandatory dress code when you have to attend the High Court or Supreme Court or the lower courts. Also, you cannot simply walk in a casual Hawaiian shirt and chill out there. A dress code is there. Abhijit, we have not even studied writs. How will you understand writs? Writ simply means order. What is writ? Writ is a synonym for order. Supreme Court and High Courts can issue orders to people, authorities, etc., to protect fundamental rights. What kind of orders can be issued? We'll discuss later on. Shiva, it is just a way to categorize some cases. The reason for original jurisdiction for MP, MLA, MLC case is that the assemblies, the councils, and the Lok Sabha, Raj Sabha seats, they belong to a particular state. So rightfully in that state, if things go wrong, we go to election commission. That's we go to the High Court of the state. That's why. Tejinder, meaning of jurisdiction. You can search for these things in the dictionary also, right? Area of influence, PAR, is called jurisdiction. Yes, Kishan, CGI must accept the recusal. Though it is, I mean, whether it is binding or not, it is not mentioned anywhere. Recusal is not mentioned in some law, etc. So the Chief Justice may refuse also, but he should accept it. If the judge himself feels that I am not free and fit and independent to decide on a case, why should the CGI force a case on him? Uh, Sejal, appellate jurisdiction, what is it to repeat here? Every case that is filed in the lower court is appealed in the High Court or can be appealed in the High Court. That's appellate. Simple. Every case that you file in the lower court can be appealed in the High Court. That's it. Now, coming to the subordinate courts. As far as subordinate courts are concerned, the lower courts are called subordinate courts, normally referred to as a trial courts. And I'll discuss the structure of the lower courts in the country. Lower courts, district courts, subordinate courts, trial courts, it's all the same. And the nomenclature can vary depending on state to state. So I'll give you a very generic structure of what these courts are like. Firstly, under the subordinate courts, we have in total 25,000 judges or judicial officers. Okay, and over 20,000, around 21,000 such courts across the country. Now, the highest court in a state is the High Court. The highest court in a district is a district and sessions court. And there we have district and sessions judge. Now, the district courts have two sides, or the lower courts have two sides to it. One is the civil side, the other is the criminal side. In the civil side, you have civil judges, right? They are referred to as a civil judge, or also called district judge in some states. They are below them, you have additional civil or district judge. In the criminal side, they are called sessions judge. These judges take up criminal matters. Below them, additional sessions judge. Okay. Now let me draw a line here. The purpose is that I want to depict that this, what you see above this, is what is referred to as higher judicial services. These are the higher judicial services. Below it, on the civil side, you have subordinate judge, senior division, then you have subordinate judge, junior division. Then you have people like munsif, etc. In the criminal side, you would have heard of this person, chief judicial magistrate. Then you have uh, additional judicial magistrate. Judicial magistrate. Then you have judicial magistrate first class. So these are various categories of judges that we have at the lower level. Various categories of judges. Now, just one more line to be drawn. All these people that you see that I mentioned here, all the people, they are all collectively called a district judge. One common name for all of them is district judge. Everybody is referred to as district judge. It is just like SP, uh, DIG, IG, ADG, Special DG, DGP. Everybody is called IPS officer. Joint secretary, secretary, district magistrate. Everybody is called an IS officer. Similarly, all these people are collectively called district judges only, and their appointment is mentioned under Article 233. Okay. At the lowest level, secondly, we have all the people below this line are a part of lower judicial service. Below this black line is the entry level, entry, where you start your judicial career. This is what is known as magistrate cum civil judge. This is a person who is not called a district judge. These are judicial officers other than district judges, and they are mentioned under Article 234. Now, how are these people hired? Magistrate come civil judge. They are hired through examination. So, in your state, whichever state you belong to, the very transparent body is called SPSC, State Public Service Commission, right? They talk about they talk about the selection of some people for judicial examination. So every state has a judicial service examination, right, conducted by State Public Service Commission. So basically the exam is just conducted by SPSC. The paper is set by the respective high court only. Interview is done by high court only, but the SPSC conducts the exam just like they conduct the exam for your state PCS. Similarly, for the state judicial service also. That is where you get this person. How to become a district judge? There are two options: either promotion, step by step, from subordinate you become a senior division, then you go to sessions judge, etc., or directly get appointed anywhere here if you are a lawyer for 7 years. So to be a district judge, you are appointed by the governor on the advice of High Court. And what are the qualifications? Number one, advocate or a pleader. Same thing. Pleader means somebody who can plead his case in the court. So pleaders are people who are allowed to fight a case in the court. Advocates. So if you are an advocate in the lower court for 7 years, or you are an officer in judicial service, this is through or via promotion. promotion. And the lower judge, SPSC conducts exam and interview conducted by High Court. So just like UPSC has some qualification, age and all, SPSC will also have a qualification with respect to the degree in law, etc., some age criteria respective to each state. This is how you become a judge at the lower level. Now, one more point. The sessions side is the criminal side. Civil side is the district side is the civil side. But don't think that a judge, if I am a sessions judge today, I can be a civil judge tomorrow. It all depends on what case I am taking up for discussion. For example, today I as a person am teaching polity. You are students, same student, same teacher. This is a polity class. Tomorrow, by magic, I also get knowledge of say geography. Same student, same person. If I start teaching geography, this becomes a geography class. Are you clear? Geography taught by the same person. Just because I'm teaching geography becomes a geography class. If I'm teaching polity, it becomes a polity class. So if a judge is sitting over a criminal case, he's called a sessions judge. If he's sitting over a civil case, he's called a civil judge. Simple. And one more thing, in the session side, these judges can award death sentences also. Are we clear on this? But the only point is, if the lower court has given you death sentence, then clearly that death sentence cannot be executed without the High Court's approval. Execution requires High Court's approval. So, in order to implement the death sentence, High Court's permission is required. If there is somebody who is not appealing against the judgment, let's say the lower court has told death sentence, and you say, okay, kill me, I don't care now, I won't appeal. Even for killing you, we have to get the High Court's approval first. Clear? But yes, the lower courts do have the jurisdiction to provide with what? Death sentence. Okay, that's it. That is all as far as the subordinate courts are concerned. We are done with the lower judiciary. Clear? Now, in our country, justice, of course, is not very cheap, especially quality justice. Nothing of quality is cheap, to be very frank. Let's be realistic, right? I mean, cheap things are only available at a subsidized rate. And that is a beauty. We believe in subsidies now. So we feel everything is cheap. So there's a misconception among certain students of certain colleges, because when you go to those colleges, you have pretty decent hostels, cheap food available. So those kids feel that the entire world is this amazing utopian place where things are cheap, where chicken lollipop is being sold at 60 rupees per plate. But that is not the reality, right? Life is not fair. And frankly, justice delivery is not at all cheap. Okay. So, how would a poor person get justice? You cannot hire Harish Salve and Kapil Sibal and Abhishek Manu Singhvi. They are charging lakhs of rupees. Sometimes these lawyers get money not to take up a case, right? Not to do your task. So that is, I mean, you don't have 38 rupees in a Google Pay account and then you are going to hire Harish Salve or Abhishek Manu Singhvi or Kapil Sibal or such kind of lawyers. Of course not possible. So what will a common man do? What will a common person do when he or she wants justice? So there is a DPSP, which is Article 39, capital A, Directive Principle of State Policy. There is a constitutional provision which says that the state should strive to provide for free legal aid. Free legal aid for the poor. Okay. So, under this provision, free legal aid may be provided. If the state has money and resources, it can try to create a situation, take steps to provide for free legal aid. So, in 1987, a law was passed called the Legal Services Authorities Act, under which a body was formed called NALSA. What is NALSA? National Legal Services Authority. NALSA. This body, NALSA, finally came into force on the 9th of November 1945. What's the purpose? The purpose is to establish a nationwide uniform network for providing free and competent legal service, quality legal service, to the weaker sections of society on the basis of equal opportunity. This NALSA, the NALSA is controlled by, or the patron in chief of NALSA is the CJI head. But CJI does not actually look into the functioning of NALSA. CJI is the busy person. So, the second senior most Supreme Court judge after CJI, he is the real executive chairperson, is the senior most Supreme Court judge after CJI. That person is the actual executive chairperson of NALSA. So it is under that person's control that NALSA functions, helping people get free legal aid. Oh, I said 1945 by mistake. It's 1995. So apologies for saying 1945 and completely jeopardizing your entire UPSC preparation. It is 1995. Okay, now I just saw some comments that I said 1945. Now, let me help you understand that there is a proper structure for NALSA. So, at the top, you have NALSA in the country. Now, under the NALSA, NALSA controls, and in each state, you have bodies called SALSA, State Legal Service Authorities. Because your case can be in the Supreme Court, your case can be in the High Court, your case can be in the lower court, your case can be in some district court. Under SALSA, in every state, you have DALSA, District Legal Service Authorities, DALSA. And under every DALSA, we don't have TALSA. Don't write TALSA. It is TLSC, Taluk Legal Service Committees. TLSC. A nationwide network, right? We have 37 SALSAs across the country. We have around 673 DALSAs across the country in every district. And I think over 2,300. And the exact number I believe is 2,351 TLSCs across the country. Apart from it, we have one Supreme Court Legal Service Committee, one High Court Legal Service Committee. And just to clarify, funds. Government of India allocates funds. So in 2021, rupees 145 crore by Government of India. Okay. So at the lowest level also, in every block, whatever lowest level of judiciary is there, we will provide you with some kind of legal service. Now, what does the NALSA do? It runs basically along four lines. Number one, providing legal assistance and aid to eligible categories of people in front of courts. Second, it also conducts outreach programs, making people aware about their rights, etc., educational awareness on legal matters. Then, Lok Adalats. Now, what exactly is Lok Adalat? We'll discuss maybe tomorrow, not today, not possible. Tomorrow we'll discuss Lok Adalats. And victim compensation schemes to facilitate rehabilitation of victims in case of any kind of compensation is required. Maybe they are some victims of some crime, acid attack, or maybe some kind of death, damage to property because of government's failure, etc. Then NALSA will fight your case in the court to get some compensation from the court also. Clear? They are along these lines: free legal aid, counseling. Just to tell you, NALSA has so far provided, just in 2022, 63.7 lakh people benefited from the provision of NALSA in 21-22 financial year. Okay. Legal awareness programs. They run programs on legal awareness. So here also, in the last financial year, they conducted 11.34 lakh programs. Workshops were conducted, then seminars were conducted, social media campaigns, etc. Then they conduct Lok Adalat. What is Lok Adalat? We'll discuss, as I said, tomorrow. So don't panic. Promoting other alternate dispute resolution mechanisms. Example of this is Lok Adalat only. We'll discuss tomorrow what is this alternate dispute resolution mechanism. Then they also have preventive and strategic intervention programs. There are various NALSA schemes, outreach programs. So you don't have to mug up all these things, but there are various NALSA schemes that are run, funded by the government, of course, through NALSA. For example, there's a very popular NALSA, Legal Service to Disaster Victims through Legal Service Authority Scheme 2010, or this NALSA scheme of Victim of Trafficking and Commercial Sexual Exploitation Scheme of 2015. One more such scheme of 2015 was the Legal Services to the Workers in Unorganized Sector Scheme, or Legal Service to Mentally Ill and Mentally Disabled Persons Scheme. So all these are various kind of schemes run by NALSA to provide legal assistance to certain categories of people. Then social justice litigation. Litigation means what? Cases. NALSA also funds and fights cases on social matters. Some very popular cases fought by NALSA are this case on transgender rights in 2014, or this case wherein they fought for the dignity of life of widows of Vrindavan. So various examples of these tasks performed by NALSA. Okay. Now, as would be a very genuine question in your mind, uh, what exactly do you mean by legal services? So NALSA will provide, and the NALSA, SALSA, TLSC, DALSA, all these will provide any and every kind of legal service that is required in the court system. Every possible legal service, right? Whether it is payment of court fees, processing fees in the court, providing service of lawyers. No, bribes will not be given by NALSA. If the court wants bribes, sorry, then NALSA will not help you with bribes. That is excluded. Okay. Uh, Providing legal service of lawyers, you'll be surprised to know that there are over 50,000 lawyers. 50,000 plus. The exact number is 50,168 lawyers, out of which you have around 25 to 30% women. 27% lawyers are women, right? So we have a lot of panel of lawyers who will provide legal help to you. If you have a case pending, you want to fight a case, lawyer is also given to you. Okay. Beyond that, you have around 44,000 other paralegal volunteers also who will help you out. Then obtaining and supplying of certified copies of orders, other documents in legal proceedings. Okay. So when a court gives a judgment, you want to get a copy of the judgment, copy of the document. NALSA, SALSA, TLSC, your lawyer there can help you out. Then preparing appeals, paper book, printing of documents, translation of judgments, all such things. The authorities can provide you with help regarding these areas. All you have to do is approach the NALSA, SALSA, DALSA, TLSC. They have their functioning website. Apply there, get in touch with them. Their lawyer will come to you, help you out based on what? Based on whether you are the eligible person or not. So, free legal services to eligible persons. This is the eligibility criteria. All women and children are included. All women and children are included. Uh, just to give you, though this figure is not important, I'm just telling you the beneficiaries in 2021. The scale of help provided by NALSA, SALSA DLSC to the people. Almost 2.2 crore women got the help of NALSA. I mean, when I say NALSA, I mean the entire NALSA, SALSA, etc. In just 1 year, 2.56 crore kids got some kind of help in some court cases. Members of scheduled caste, scheduled tribes, 76 lakh scheduled caste people got help. Around 28 lakh scheduled tribes people got help. These numbers are not important. I'm just giving an estimate. You should also understand, as an informed citizen, the amount of efforts being taken by our country itself to provide for legal aid to poor people. Then transgenders, around 14 to 15,000 transgenders got help. Industrial workmen, around 50 lakh industrial workmen, they got help, right? Victims of these mass disasters like violence, flood, droughts, earthquakes, all such things. 6 to 7 lakh people here also got help, right? uh, Disabled persons, right? In our year of 2021, 27,000 disabled persons got help through of free legal service. Then people in custody, over 2 lakh people in custody. obtained the help of these organizations. Victims of trafficking in human beings or begar, right? Victims of trafficking in begar, roughly, I believe this number was 13 to 14,000 people getting help. And look at this provision: persons whose annual income is less than how much? How much? 1 lakh. Uh, the real poor of the country, actually. So when it comes to providing some kind of free legal help, then the real poor is 1 lakh. Otherwise, the poor is 8 lakhs, right? We know in our country with such purchasing power parity, somebody who's earning 8 lakh rupees is not poor person. Yes, he may not be living the life of Dan Bilzerian or Andrew Tate, I understand it. But he is not a poor person by any means, right? So this is how the government plays politics also. When you have to give freebies, vote bank, you say, come on, reservation criteria 8 lakhs, EWS criteria 8 lakhs. And when you have to give service to people, 1 lakh. And roughly 83 lakh people benefited from this particular criteria. So look at the scale of benefits being given through NALSA, SALSA, DLSC, TALSA, all these things. Anyway, solve a question. Came in the year 2020. Please mark the answer. Easy question. Nothing much to discuss here. Okay, a lot of you marked this correct. 1 is correct, 2 is correct, this is wrong, this is wrong. All senior citizens. How could somebody mark this correct? All senior citizens also includes Rajnikant, Narendra Modi, right? Uh, After some years, Salman Khan, Shah Rukh Khan, all senior citizens. You can't include them as giving free legal aid and all. Common sense. Okay. So A, 1 and 2 is the right answer. So let me also clarify one thing here. Just to give you the correct fact here, this income of 1 lakh rupees is actually not the same everywhere. It varies. In some states, for example, Mizoram. Now, in this great state of Mizoram, they are saying that if your income is about 25,000, sorry, we can't help you. Annual income 25,000, no legal help for you. Very weird. But in most states, like say states of Andhra Pradesh, uh, Assam, Himachal, Haryana, Maharashtra, you can add names of these states. Maharashtra, Tamil Nadu, Himachal Pradesh. There the limit is 3 lakhs rupee actually. So you can be given legal help if your income is 3 lakhs or less. Then some states like Bihar, Rajasthan, etc. In these states, the limit is 1.5 lakh rupees. So this UPSC question was not entirely correct actually. This is factually a very poor statement. And even for transgenders, let me clarify, for transgenders, this is only in Delhi. Okay. Not in other places. So again, a very poor statement made by UPSC in the framing of the sentences. Anyway, that's it as far as the NALSA is concerned. Free legal aid to the poor people of this country, the deserving people of this country. Okay. Moving on now to judicial independence, a very important element. Sir, is this number? This number, I have said it, I think 4 or 5 times now. This number is not important. It is just for you to understand the importance of NALSA, right? Or annual income. The only problem with the morning batch is that most of the intelligent people here are partially asleep. So that is a challenge that we face. Half asleep, watching YouTube, etc., and suddenly wake up. Oh, what happened? 25,000. What is 25,000? Tell me. So it's again interesting. So now judicial independence. We would have to also agree that judicial independence is very important. It's extremely important, without which uh, I'm sure this entire country would no longer be a democracy, thanks to our amazing politicians, right? But why do you need independence? Judicial independence provides for a very big advantage. These are the reasons. Firstly, separation of power. L E J. When you have separation of power, LEJ, legislature, executive, and judiciary, the principle of separation of powers will never be effective because you will not be able to have checks and balances. How will the judiciary check the executive if they are controlled by executive? Independent judiciary can be a more effective check on the independent judiciary can be more effective check on the executive and the legislature. Point number one. Secondly, see, in the court system, more than half of the cases pending at any point of time in any court, they are against the government only, right? Executive only. Imagine the Supreme Court, some case is pending against the government. Tomorrow, judgment is about to come. Previous night only, the judges get a message from the law minister. Tomorrow, judgment is there. If you give a judgment against me, against the government, we will reduce your salary to 10 rupees per month, right? That is why, to ensure independence, their salaries can't be reduced. You can't be harassed. You can't be controlled by the executive. So we need the judiciary to be independent because in most cases, you will find that a case pending in court is against the government only, right? Number three, rule of law. What is rule of law? Rule of law, in short, simply means the limitation on the state's power. State cannot have arbitrary power. That is not possible. There will always be limitations on the state's power. Okay? The governance in the country is based on principles of law. Rule is of law, not of some minister or some people. No, no. Laws rule. Law is the king of all the kings. Anybody who comes to power has to enforce the law. All manner of people are equal in the eyes of law. Rule of law. Who will uphold laws? Who will keep a check on the government's power? Right? Who will keep a check on government's power? Of course, a check on government's power will be done by a judiciary, but if it is independent. Okay? Then, now, in our country, or in any democracy, majority and their rights. They are protected by the parliament, because in a democracy, especially like that of India, majority is what elects the parliament. Yes or no? Democracy. Then who is going to uphold the rights of minorities? Minorities meaning caste minorities, religious minorities, sexual minorities, linguistic minorities, any kind of minority, right? Who will protect your rights? Judiciary. Independent judiciary is very important to uphold the democratic rights of people. Otherwise, this would become a tyranny of the majority. To ensure that democracy does not translate or become the tyranny of majority, we need an independent judiciary to uphold and preserve and protect the rights of every group of people in this country. And lastly, to preserve federalism. Norms of federal polity can never be preserved if we have a judiciary controlled by center. To protect states' powers. What is federalism? Division of power between center and state. Center is almighty, all powerful. It can keep on modifying the constitution, taking away all the states' power. But the Supreme Court, which takes up these matters under Article 131, original jurisdiction, it has the authority to keep a check on the center's power and find the right balance, solve such federal disputes, right? And that is the reason why we need an independent judiciary to solve any kind of federal disputes in a fair and transparent manner. Okay, so this is the need, the reason, the need for judicial independence. Now, of course, are there steps taken for ensuring independence? Yes. In the constitution, at least for the High Court and Supreme Court, ample steps have been taken. Firstly, appointment. Appointment, look at the appointment now. Appointment is now of the collegium system. Too much of independence. Removal process. Article 124, Clause 4 requires a special majority, and such is the difficulty in the procedure that sometimes even corrupt judges have not been removed. Right? Then there is an Article 121 of the Indian Constitution and also 211. This is for the parliament and this is for state legislature. The conduct of the judges cannot be discussed in the legislatures. You cannot discuss the conduct of judges in the legislature. Not allowed. Okay, it is a breach of your privilege. A privilege motion can be initiated against you. You can be expelled also. Then they are debarred from future practice. To ensure their independence in behavior, they are debarred from practicing as advocates in future. Their salaries, their allowances charged on the CFI, CFS. They have the power to make their own rules. Article 145. Then they have contempt power also. So because they are court of records, they have power to issue contempt. What is contempt? Contempt means you make any derogatory remark against the court. That is called contempt. There's a law in the country made by the parliament called Contempt of Court Act 1971, which provides power with to the Supreme Court and High Courts to punish people if they make negative remarks, derogatory remarks against the what? Courts. So That is why we should not make any derogatory remarks against the court, and that's why we don't. We always respect the courts, right? So whether they are right or wrong, I mean, they are of course right. So we always respect the courts. That's it. Ensuring independence. Solve this question. Came 10 years back. Old question. Corrupt judges means, I gave the example yesterday. V. Ramaswamy, Soumitra Sen. These were examples of some judges who the inquiry committee found them to be corrupt. Okay, so first statement. While appointing a Supreme Court judges, the President of India has to consult Chief Justice of India. Yes or no? Okay, correct. The Supreme Court judges can be removed by Chief Justice. There is no such provision. Supreme Court judges can't be removed by the Chief Justice. 2 is wrong. Remove this. 1 is right. This has to be the answer. That's it. Done. The salaries of judges are charged on the CFI, to which the legislature does not have to vote, is also correct. And all appointments of officers and staff of Supreme Court of India are made by government. No. The appointment is made by the Supreme Court. After consulting Chief Justice. No, after consulting President. So 4 is wrong. 1 and 3 being the right answer. Okay. That's how you could solve questions earlier. Good old days of elimination now gone. Coming to the next topic, issues concerning judiciary. The first issue is the pendency of cases. Pendency of cases. Pending cases. All the cases pending in the court. So every batch I take, I give out some figures. But there's always this problem of, the pending cases being 4.7 crores, 4.84 crore, 4.91 crore. Finally, we have crossed the great landmark of 5 crore pending cases. In our country, in total, as of now, we have more than 5 crore pending cases. Right? Great achievement of judiciary. I mean, the problem with judiciary is that a lot of pending cases are there. So, in the Supreme Court, we have around 68,000 pending cases, 68 to 69,000 pending cases. Now, you can simply write around 70,000. The exact number is 68,745. Nobody will give you any award to write an exact number. It's okay. No need. Somebody randomly can be impressed by you. But in the exam, it's not possible also. Just write 70,000. Across the high courts, 60 lakh cases are pending. 60 lakh cases are pending. Currently, it is more than 60 lakhs. It's 60.94, almost 61 lakhs. You can simply say 60 lakh cases. And in the subordinate courts, the lower courts, we have 4.41 crore cases. These are the pending cases in the country. Are you able to understand? Cases pending in the court amounting to a total of 5.02 crore cases pending in the court. That's it. 5 crore 2,76,893 cases pending in the courts across the country. Now, just getting down to some finer nuances. Pending for 3 years or more. Pending for more than 3 years. You'll be surprised that across high courts, 63 to 64%. The current figure is 63.34%. This is a range is okay. These cases are pending for more than 3 years. In the lower courts, this figure is 43 to 44%. Pending for more than 3 years. And pending for more than 30 years across the country, there are around 1.75 lakh cases which are pending for more than 30 years. Okay. Now, let me also clarify. High Court has 60 lakh pending cases. Not every High Court is the same. If you look at Allahabad High Court alone has 10 lakh pending cases. Second highest is Bombay High Court with around 7 lakh pending cases. Then we have the Madras High Court with 5.5 lakh pending cases. Some high courts like Sikkim High Court. Sikkim High Court currently, I think, has around 153 pending cases only. So the pending cases varies from one high court to another. One more thing. In 2018, there were 2.9 crore pending cases. Okay. So in 2018, Niti Aayog came up with a very important document. So Niti Aayog said that to clear the backlog. What is backlog? That is pending cases. Like in your examinations, if you fail, backlog of papers. So to clear the pending cases, if no new case is filed now, that is in 2018, all the pending cases can very easily be cleared in just 324 years. So in such a small span of time of 324 years, we can finish all the pending cases in the country. Right? So this is with respect to, the average pendency in the courts is 15 years. When you file a case in the court, rest assured that judgment will come in 15 years. Okay. So, Supreme Court's motto is where there is dharma, there will be victory. Where is a dharma, we don't know. But anyway, let's not make all these statements against judiciary. Okay, please respect the judiciary. Now, what is a problem? If the pendency is there, what is a problem? This is a problem, right? Of course, that's the harsh reality. First things first, we have been hearing this statement right from our childhood: justice delayed, justice denied. So if there's too much of delay, then what exactly is the meaning of justice? We are not really sure. Also, let me just clarify one thing here. Because of cases pending in the court, lot of people in the jail are actually under trials. Who are under trials? Under trial means that person who has not been convicted. Who has not been convicted. The case is pending in the court. The court has not given him or her bail and he is in the jail. So, very high under trial population. Just to clarify, the entire jail population was in 2021, the 2021 NCRB data was 5.54 lakh. Prisoners, out of which how many are actually under trials? Some of them are convicts who are in jail because of punishment. How many are under trials? 10, 15, 20, 30, 77%. 77% people in our jail are actually under trials, meaning because of delay in the case, they are in the jail. Right? So, I am mentioning what is under trial population, and you're asking the exact same question. Under trial means somebody who is in the jail, who is accused of committing a crime but has not, may or may not have committed the crime. He's just an accused but has not been given any punishment, no conviction, accused. Okay, let me write this here for our innocent people. Accused in jail who was not given bail. The poor people mostly, right? Supreme Court had recently said that our prisons can only manage 3 to 4 lakh people, and we have over 5 lakh people in jails. Government take steps. Government takes steps. If you give bail to people and solve cases quickly, 77% people come out of jail. Let's say even half come out of jail. The jail prison population will come down. For everything, they'll point out at somebody else only, right? But anyway, we can say that judiciary is biased, but will we say it? No, I am not saying they are biased. We can make such statements. You can make such statements. I won't make such statements, please. Secondly, increasing tendency. Now, what happens also is one more thing: wastage of resources. Why? Resources of judiciary, resources of the litigant, petitioner. If the case drags on and on for too long, the wastage of resources. What kind of resource are we talking about here? Resource of time, resource of money. Both resources are getting wasted. And slowly and steadily, people start losing faith in the judicial system. What's the point in going to court? So I believe there's a movie couple of years back, Jolly LLB, the part one, where the movie shows, the judge there shows, says that even today people have faith in judiciary, right? Wherein people tell each other after any fight, I'll see you in court. I don't think anyone says this, right? Anyone in their right frame of mind will not think of going to court because they know the court system. They have heard and seen enough in the court system of the court system that it is manipulated by the rich and elite people, and there is too much of delay, right? Also, so increasing tendency to employ extra legal means. What is this increasing tendency to employ extra legal means? Think of this. You take a loan from a bank loan. You take the bank loan from some, say, government PSU, PSP, public sector bank. The bank has no interest in getting the loan back. They'll file a case in the court. The case drags on and on. You run out of the country and all, no problem. These private sector financiers, small time financiers, what they do is they will also give you loans at decent rates only. And they know very well, if you don't repay the loan, they can also go to court and file a case. But who will go to court and file a case? They'll hire some people, protein powder fed people, and their only task is to go to your house and collect the EMI. The moment you fail to give one installment of EMI, the people come to your house and then they'll give you a nice treatment that you will pay EMIs for the next 10-15 times also. Why? You are employing extra legal means because you have lost every faith in the system. You know very well that if I file a case in court to recover my 1 lakh rupees, the case goes on for 10 years, I'll only be losing money, right? So this is with respect to the adverse implications, right? It has a tendency to increase criminality also in society. Let me tell you, while discussing capital punishment, I had mentioned this point that it is more important that there's a guarantee and certainty of punishment than the severity of punishment. Punishments being severe, okay, definitely deserving in cases. But what is more important is that the punishment has to be guaranteed, certain punishment. In the current context, not really. Anyway, let's end our discussion here only today. We have an extra class on Saturday, 7 to 10:30. I'll be repeating, writing it here again. Saturday, 7 to 10:30, extra class. Please don't forget. Okay. So that's all for me today, guys. Jai Hind. And tomorrow we'll take up for discussion the reasons why do we have so much of pendency, how to solve pendency, other issues, concerns, and also judicial activism. Leaderboard for the day: Gauri Rotela, Vikram, Vijaditya, Sanskar, Tulsi, and Uday. These are the leaders for the day. Then Ramavat, Krishna, Pranita, Rupal, Mahima, Hari, Neeraj, Dinesh, Anuradha, Shargun, Jhansi, Pridarshini, Jigar, Nirbhay, Selva, all such people. Okay, that's it. Litigant, Sachin, litigant. Google search, word meaning, petitioner. When you go to court and file a case, you are a litigant. People who file case in court are called litigants. Okay. Anyway, please make sure that you are following Monthly Magazine. I hope by now all of you have covered the entire May magazine. Please don't tell me you have not covered May magazine. Right? It is too much of time. Please move on to April. Secondly, this is only meant for those people who are taking the exam next year. Yesterday was Yojana Kurukshetra, I believe. So today, back to Yojana for the month of May. Political theory and also revising the PPTs. In case you want to read Lakshmikant, you can read chapter 26 for now. It is with respect to the Supreme Court. Then There are other chapters also, as far as the high courts and lower courts are concerned. Read chapter 26 for now. That will be sufficient. Once we are done with judiciary, towards the end, I'll just tell you all the chapters and the relevant articles also. As of now, please focus on covering this portion. And yes, Yojana Kurukshetra has to be covered just gist only, not the entire magazine. Read, that is mandatory for everybody to read. Don't waste time. Yes, Ananya, seats are reserved. You please refer to the notes there. For in panchayats, it is mandatory reservation, but in case of municipalities, amongst members, mandatory. In case of chairpersons, optional. stands for monthly magazine. Somebody is waking up right now. It's monthly magazine. No Arnab, it is not charged. That's a difficult question to address, Surya. Let us first discuss activism and then we can come up with some conclusion. Jyoti, additional judge is just like a judge of High Court only, no difference. He is a part and parcel of the High Court. He is not given some special kind of cases. It is just a way to promote people to make them permanent judges. See their behavior and knowledge first and make them permanent. Nikhil, then you please study Indian Constitution at work. Right? Read that NCRT book. Vivek, how to cover Yojana magazine? How to cover magazine? Using some brown piece of paper, you can cover the magazine. But on a serious note, what kind of question is this? Go to the website, Google, type on Google, Yojana Kurukshetra gist, Byju's, download the gist, mug up the gist. What's difficult? But 8 hours of studies are required. Let me be very clear here. I can't give you false sense of hope and all that 2-3 hours are okay. It is not okay. If somebody is telling you, you are being misinformed completely. You want the best job in the country to harass everybody in the country as an IPS officer with 2 hours of studies. That's not going to happen. It has never happened. It will never happen. That's why I said reading the gist of Yojana Kurukshetra. Gist. Take some effort to download the gist of Yojana Kurukshetra, save some data by using less data on YouTube and download some gist and mug up the information. PIB not important. That is all covered in the monthly magazine. How should we cover in one day? I am giving you 3 days time to cover Yojana for every month. Yojana month of June, I gave you 3 days of time to cover. Puja, Sunday test is for mains and prelims. See, both prelims and mains both. Prashik, as of now, don't worry. Questions will take some time. No problem at all. It's okay. Your time frame will improve once you have more knowledge and your writing speed also increases. It'll take some time. Anuradha, we have an option to create an all India judicial services. So in case that is there, that is also covered. That's why the union. Nirbhai, you have to go on the website and apply there. Yes, Priyanka, you can, but once you are disqualified, you're disqualified. Does not mean that once you join the party again, you're not disqualified. Palak, the process varies from state to state. It depends on the High Court, the procedure followed by High Court. Srimant, there's nothing called a personal case. It's a civil case. Civil case is where you have some kind of compensation being given. You go to a shopkeeper, the shopkeeper gives you a product, the product is not working, right? That's a civil case between both of you, the shopkeeper and you. It's not a criminal case. It's not a crime against society. You attack, assault somebody, that's a criminal case. By all those people who cannot cover Yojana Kurukshetra, don't study. What's the big deal here? It's okay. Relax. You have so many years left. 6 attempts, 9 attempts. Chill. 11 minutes is a pretty decent time to write an answer. Tenure of district court. There is no tenure of any kind of judge in the country. Till you die, age of 60 retirement. Functions of Indian judiciary. The functions that we have seen, jurisdiction, all the powers of the judiciary are the function of judiciary. Okay, I believe your questions are largely addressed. 15 marker question, any score of above 45 or 50% marks is a very good score in answer writing. So in a 15 marker question, scores above 6.5, 7 are pretty decent scores. In a 10 marker question, scores above 4.5 or 5 are pretty decent scores. Okay, guys, that is all for me for today. Let's meet tomorrow. Till then, Jai Hind.